Welcome back to this morning's edition of Continuing Contracts and Coffee, mostly because it takes a lot of coffee to do contracts, but hey, we're going to get through it. So today we're going to talk a little bit more about the Offer to Purchase and Contract Form 2T. So the Offer to Purchase and Contract Form 2T is 13 pages long. In our post-licensing class for the North Carolina Real Estate Commission for all brokers, we spend 12 hours on the offer to purchase. So it's a lot of information to cover, mostly because it's so important, and as brokers, something we need to understand. So in the interest of time, and because I know you guys have extremely short attention spans, I'm really just going to hit it a page at a time. So each of the subsequent videos will be a page of the contract. Some will be a little shorter, some will be a little longer, depending on the importance. We're going to start on page 1, which is going to be a little bit longer because that's where a lot of the important information is located. So if you do not already, you should get an offer to purchase and contract in front of you, and we're going to go through it. So I just want to look at the start of the offer to purchase on page 1. Remember, it is an offer until it becomes a contract. It is not a contract until all parties have signed and dated. So under section 1, we're actually going to define the parties. The parties of the contract on the offer to purchase are always going to be the buyer and the seller. And more specifically, we need to detail exactly who the buyer is. If it is a corporation, we need to, if an LLC, for example, we need to make sure that we are helping the appropriate party and who is the signing party. If they are husband and wife, you would indicate that the buyer and or seller are husband and wife in this section. So for example, for seller, it might be Jane A. Doe and John B. Doe. The appropriate way to say that would be John A. Doe and husband Joe B. Doe. I think it was Joe. You get the point. To indicate in the line that they are husband and wife. Not enough coffee. The other thing to consider here is if, for example, you're working with an estate, does the person who is your contact at the estate have the authority to sell real property on behalf of the estate? That might be a question for their estate attorney. To make sure that you're dealing with the right person. Otherwise, you might have an invalid contract where the person you're working with doesn't have the capacity to sign. Other things to consider are things like a trust. If you are dealing with a trust, your client or the signator on the contract would actually be the trustee. You may very well be contacted by the beneficiary, the person who would benefit from the sale of a property or the purchase of a property, but your actual client would be the trustee. So making sure you have the appropriate parties on the contract is very important, because if we should miss somebody, if we don't have all parties and defined and clearly put into this contract, that we could be creating a document that may not be enforceable under court law or under any license law. So we want to make sure that we are very specific with our parties in section paragraph 1A and B. In addition to being specific about the parties, we need to be very specific about the property description. And this is case in case, again, where people are not doing a great job of describing the property. It does ask for street address, city, county, things like that. Those are very basic, not sufficient legal descriptions. So, for example, if I put in 123 Main Street, I'm under contract to buy hundreds of 123 Main Streets throughout the country. So we want to put in as much information there in the address as we can. But where it gets into the legal description, we want to be very specific. Get the parcel identification number, reference a plat, reference a deed book. If you're going to fill out those sections, reference them. Go to the Register of Deeds for the county in which the property is located and pull the deed and look at the deed book and page and say, is the person who's on that deed the person that's identified as the seller in this offer to purchase? So we want to make sure that we have all the correct parties, and that's a big part of pulling the deed, and you'd need the deed book and page. And likewise, if it has ever been subdivided, it is for a neighborhood, for example, it's going to have a plat book and page. So you would reference the plat book, the deed, and the deed book. So we always want to be as specific as possible in this capacity. There's actually an other description here as well. So it might be appropriate to put the house in 3 acres located at the corner of 5th and Main. And that way you can be very specific about your legal description. No court, no third party reading this contract would ever wonder, what are they talking about here? Which property was that? Did they mean to include the extra acreage or the lot next to it? So be very, very specific in that legal description so it can never be misinterpreted as to exactly what it is that the parties, who we are very specific about describing, are actually under contract to buy and sell. So those sections are very, very important. Also, if you'll remember from the last video, if there are any blanks that you do not know or cannot find, it's appropriate to fill in NA or none, just to make sure that they are filled in throughout the contract. And that specifically applies to the next section, which is subsection D of paragraph 1, where we start getting into numbers. D is the purchase price. This is how much you're offering to purchase the property for. So let's say for the first line, it would be $100 on the following terms, so, or $100,000, sorry. So let's say we're making a $100,000 offer. We would put $100,000 in that first line. Now this kind of works like a subtraction problem, because whatever's on the last line will typically back out whatever's in the lines in between. Whatever's in the first line, the $100,000, will subtract out everything in between that and the last line. The last line there, what says the balance of the property due at settlement, would be $100,000 minus the due diligence, minus the earnest money, and minus the additional earnest money, and then we would get down to the balance that would be due at closing. Now I want to take a minute and spend a couple of seconds describing due diligence and earnest money. We talked a little bit about it in the last video, but it's very important. Due diligence money and earnest money are not contract requirements. However, depending on your market, it's probably an expectation. The amount of due diligence, there's no set rate, there's no rule of thumb. It is 100% negotiable. So if a buyer wants to offer, $100 due diligence, they can. If they want to offer $1,000 due diligence or $2,000, they certainly can. It's just a good faith gesture towards the seller. Remember though, regardless of whether they purchase it or not, due diligence money is typically non-refundable. So that non-refundable money will go to the seller, be put in their pocket. The check is made to the seller directly. So the moment we go under contract, whatever that amount of money is for the due diligence is written to the seller, taken to the seller, and the seller puts it in their bank. Now it'll show up as a credit at closing if the buyer does go to close, but in the meantime, that is the seller's money. So, and the buyer needs to be prepared that that check's going to clear the bank. And so that due diligence fee is basically an amount of money that they're writing to purchase a period of time. And in that period of time, they get to do any and all inspections, their appraisal, their loan, anything they feel like they need to do to make sure they are ready to purchase that property. And you heard that correctly in the sense that I said their loan, their appraisal. There is no loan contingency in this offer. So you need to make sure that if you are the buyer, representing the buyer, that you buy yourself enough time in this due diligence period, which we'll get to in the next page, and talk about how much time you need. But you need to make sure that that amount of money is purchasing the amount of time that you need to get any and all inspections done. Remember, a buyer can walk away and terminate for any or no reason at all during that due diligence period. They don't have to give a reason. The only thing they're ever out is that due diligence fee. So if you're a seller, make sure it's appropriate for the amount of time in which you're going to be having your house off the market and under contract. If you're a buyer, make sure it's the amount of money that you're comfortable that if you need to walk away, you can walk away. Earnest money. Earnest money is similar, except earnest money gets held into a trust account. So buyer writes the earnest money at the time of contract. It will be put into a trust account. Either the listing firm typically will hold it in their trust account, or more commonly now we're seeing attorneys, the closing attorney, take their earnest money and put it in their trust account and hold it in their possession until closing. Now earnest money is safe. It is held in trust. It stays there. It's still the buyer's money. It's just in a safe place. It will stay there until closing, at which time it's credited to closing. If, in fact, the buyer terminates before the due diligence period, 5 o'clock on the due diligence date, which we'll get to soon, then that earnest money gets refunded to them. If they go beyond that 5 o'clock period on the due diligence date, then that earnest money would be entitled to the seller. Now, keep in mind, I said entitled to and should, because when we terminate a contract, we have to actually fill out a termination of contract agreement. This says buyer and seller mutually agree to terminate this contract and release this earnest money. And on that termination, they would then agree to release the earnest money to the buyer or agree to release the earnest money to the seller. But both parties have to sign and have to agree to where the earnest money is going. Now keep in mind, if you have a stubborn seller or somebody who knows that they're going to have to give that earnest money back and they're not real happy about it because they've been under contract for 3 weeks, negotiations didn't go well, and they just, for whatever reason don't feel like giving it back, you should remind them that you have that prerogative. You don't have to sign this termination, but keep in mind that if they have to go to court to recuperate the earnest money, which they're contractually entitled to, you would also end up having to pay them that earnest money and any of their court costs that they incurred to get to that point. So for $2,000 earnest money check, it may end up costing you $25 or $3,000 or $4,000 just to get your earnest money back, or to go to court so that you have to give it back. So it really doesn't behoove anybody to be that stubborn seller, and you need to have those conversations with them and say, hey, just sign the form, they terminated during due diligence, refund the earnest money, or hey, Mr. Buyer, you are past your due diligence. You need to sign knowing that you're going to lose your earnest money, because the same situation applies there, where if the seller has to take them to court to get the earnest money that they're entitled to because it's beyond 5 o'clock on the due diligence date, then at that point in time, they would also be able to recuperate any costs that it took them, legal costs, from the losing party to get there. So earnest money and due diligence are very, very important parts of information. So under paragraph D on page 1, purchase price, due diligence, and earnest money are probably 3 of the most important items that any broker or buyer or seller needs to pay attention to closely. So after that, we get into additional earnest money, which means maybe we're going to provide some additional earnest money at a later date. Typically not going to see that a whole lot, but if you use that, remember that it is under, I think it's the 4th one down, a time is of the essence date. So additional due diligence money, additional earnest money is time is of the essence. Remember to be very cautious with time is of the essence. That is a drop dead date. There is no forgiveness there. So anytime you see time is of the essence, always know that whatever time you put there is a drop dead, non-negotiable, no wiggle room type date, which, by the way, due diligence date is a time is of the essence. Closing date is not time is of the essence. We'll get more on that later. So your additional earnest money, probably not going to use it that often, but if you do, that's the appropriate place. The next one is by an assumption. If you're doing a loan assumption, probably not doing that a lot now, but as interest rates tend to creep up and people are holding mortgages with 3-4% interest rates, and now the going rate for a new mortgage is 7 or 8%. Loan assumptions may become a big part of your business going forward. So probably not using the loan assumption a whole lot now, but that's where you would use it. If you're doing any seller financing, the amount of seller financing would go there. And the next section is by building deposit. So if you're doing a building deposit for a new construction addendum, which is also one of the addenda that we'll look at in later videos. And then last, the balance would be how much after all of those, the purchase price minus the amount of money so you've already written out or be getting credited, how much is due at the closing table from the buyer. And that, my friends, kind of concludes page 1 of the contract. Took me just under 15 minutes to get through page 1, but we will continue on. And honestly, page 1 is one of the most important pages of the contract. So, subsequent videos will be much shorter, but as I mentioned earlier, contracts tend to require a lot of coffee. So keep feeding your caffeine and stay tuned as we will move on to page 2 of the